Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video, we're going to discuss the difference between IR-1 and CR-1 visas. Some people don't really understand the difference. Basically, what we're talking about here are spousal visas for the spouse, probably Thai if we're going to be dealing with them, although we deal with these matters throughout the region. The foreign spouse of a United States citizen. So that individual who's already married to a USC is going to be entering the United States in either IR-1 or CR-1 status. It's also possible to enter on a K3 visa, but as explained in another video on this channel, K3 visas have become sort of a thing of the past due to procedural and administrative closures. But the question is, what's the difference between these two categories if both visa categories are specifically for those those foreign nationals married to United States citizens? IR-1 is immediate relative and CR-1 is conditional resident. So what's the difference here? Well, it's the conditionality of the underlying permanent residence of the foreign national spouse. And what we're talking about here, and a term which could only be derived in the immigration bureaucracy, in my opinion, is the notion of conditional permanent residence. So it's permanent residence with conditions. Basically, some years back, in an effort to sort of forestall or frustrate so-called marriages of convenience, or what's often been described as sham marriages, basically the immigration apparatus came up with the decision, and I believe it was also passed in various different forms statutorily, basically came up with the differentiation between conditional and unconditional residency. So those married to an American citizen for less than 2 years at the time of their first entry into the United States as an immigrant, those individuals are going to be treated as CR-1 category immigrants. And CR-1 means conditional resident. And what this means is the marriage thereafter, after the entry into the United States, so long as the couple in question stays married and files what's called a lift of conditions 90 days prior to the 2-year anniversary of the foreign national's entry in the United States, so long as that happens, basically the conditionality of the residence is lifted and the individual can stay in the United States. So where the rubber hits the road on this issue is the fact that U.S. immigration, if you don't stay married for those 2 years and there's a divorce that occurs in the interim between entry and the required lift of conditions, it's going to be grounds for at least a scrutinization of the situation or a deportation, possibly. Essentially, the individual will lose their status because of the conditions have not been lifted of their status, and on top of that, they're not meeting the conditions of their residency pursuant to the type of visa that they applied for in the first place. So CR-1 status, although it is lawful permanent residence, it's conditional lawful permanent residence, which has to be lifted following entry in the United States, approximately 2 years later. IR-1 status, immediate relative, that designation basically denotes that the American citizen is married to a foreign national, and they have been married for 2 years prior to the initial entry of the foreign national in lawful permanent residence status, and therefore that individual, that foreign national, will enter the United States in unconditional permanent residence status, and will be issued immediately a 10-year green card. And so long as some sort of inadmissibility issue comes up, as long as their immigration record stays clean, essentially, that individual can continue to renew a 10-year green card into the foreseeable future. The green card itself does not even denote the actual residence, and in fact, in IR-1, someone entering the United States in IR-1 status is going to have permanent residence, unconditional permanent residence, basically from their first entry. A CR-1 status holder is going to initially be issued a 2-year green card, again 90 days prior to the 2-year anniversary of the arrival in the United States in immigrant status. That individual can go ahead and apply for a lift of conditions, and after the lift of conditions is granted, that individual will be issued a 10-year green card thereon.